this lecture, we shall attempt to answer one essay question on constitutional law. And this question reads as follows. And I quote, assess the strategies and instruments provided in the 1992 Constitution in respect of how a person or citizen might protect his or her fundamental human rights and freedoms guaranteed under the Constitution. Your answer must reflect specific provisions of the Constitution and decided cases. Again, assess the strategies and instruments provided in the 1992 Constitution in respect of how a person or citizen might protect his or her fundamental human rights and freedoms guaranteed under the Constitution. Your answer must reflect specific provisions of the Constitution and decided cases. Discuss. Remember, every essay question, you must understand what the question requires of you. Structure your essay. Have your different parts. Have a very strong introduction. And then what do you say? Make sure that you tell them what you are going to say. You say it, and you tell them what you have said. As much as possible in your structure, make sure every paragraph deals with a different legal point, and you support all your points with appropriate legal authorities. Very common mistakes. People will be referring to authorities that are illegitimate. Wikipedia, Google sources are not proper authorities. Make sure you support it with relevant authorities, decided cases, and constitutional provisions. So we shall begin with the answer. Let's take a look at the answer. Like I said, you have a good introduction. Tell them what you are going to say. You say it, and you tell them what you have said. So let's see how the introduction looks like. This essay endeavors to evaluate the strategies and instruments provided in the 1992 Constitution of Ghana concerning the protection of fundamental human rights and freedoms guaranteed under the Constitution. The essay will delve into specific provisions of the Constitution and examine decided cases to provide a comprehensive analysis. The essay will be divided into 5 distinct parts. First part shall broadly explain the fundamental human rights provided under Chapter 5 of the Constitution, which contains Article 12 to 33. In this part, I shall highlight the obligation placed on all organs of government under Article 12 to respect the human rights provisions by virtue of Article 290 of the Constitution. Which by virtue of Article 290 are part of the entrenched provisions of the Constitution. In the second and third parts, I shall demonstrate how the High Court and the Supreme Court may, in appropriate cases, assume jurisdiction to enforce the fundamental human rights and freedoms in the Constitution. So this is me talking about the second and third parts. More specifically in the third part, I shall rely on the case of Edusei No. 2 and Attorney General, as well as Article 33 Clause 1 of the Constitution, to demonstrate that if a person is alleging that his fundamental human rights have been breached, about to be breached, or have been breached, then it is the High Court alone that has jurisdiction to entertain an application by that very person for the enforcement of his fundamental human rights. So this is supposed to be second part. So now in the third part, I shall then rely on the case of Fediak versus Public Universities of Ghana and others to demonstrate that when a person is seeking to enforce a human right provision contained in Chapter 5 of the Constitution, which is not brought in the personal interest of that person, but rather in the public interest, then such a person can properly bring an action to the Supreme Court for a declaration to that effect. Now the fourth part. In the fourth part, I shall discuss the remedies that have been provided for under Article 33 of the Constitution to enable the High Court to give effect to its orders for the protection of fundamental human rights. Notable amongst these remedies to be discussed are certiorari, mandamus, and prohibition. The fifth and the final part shall conclude the discussion. This is an introduction. It tells them what you are going to say. So after telling them what you are going to say, the next thing is to what? Say it. So we must now say it, beginning with the first part. What do you have in the first part? We are going to broadly explain the fundamental human rights provided for under Chapter 5 of the Constitution. And it reads as follows. To start with, Chapter 5 of the 1992 Constitution provides for the fundamental human rights and freedoms of persons. Notable amongst these human rights are the right to life, liberties, dignity, equality, and privacy, which have been provided for under Articles 13, 14, 15, 17, and 18, respectively, of the Constitution. Also, the right to fair trial, expression, and administrative justice have been provided for under Articles 19, 21, and 23, respectively, of the 1992 Constitution. Now, let me briefly comment about this part. This is a very nice way to condense statements that could be made in a long manner. So we've lumped up all the human rights. So we've lumped up a lot of them. Right to life, then liberty, dignity, equality, and privacy. And you've added the articles to follow in the respective manner. So Article 13 goes for article right to life, 14 goes to liberties, 15 goes to dignity, 17 goes to equality, and 18 goes to privacy. Some other person would have said that Article 13 deals with right to life, 14 deals with liberties, 15 deals with dignity. Spending more time. You can make your work easy. So I'll take that portion once again. Notable among these human rights are the right to life, liberties, dignity, equality, and privacy, which have been provided for under Articles 13, 14, 15, 17, and 18, respectively, of the 1992 Constitution. Also, the right to fair trial, expression, and administrative justice have been provided for under Articles 19, 21, and 23, respectively, of the 1992 Constitution. What is more, Article 33, Clause 5 of the Constitution clearly demonstrates that the human rights provisions contained in Chapter 5 are not exhaustive. In its express language, it indicates that the human rights provisions mentioned in Chapter 5 shall not be deemed to be excluding human rights provisions which have not been specifically mentioned in Chapter 5, but which are deemed to be inherent in the democracy and necessary to secure the dignity of man. The next part of this essay shall address the measures put in place to ensure the enforcement of these fundamental human rights. So it means that this brings us to the end of the first part, because in the first part, we said we shall broadly explain the fundamental human rights that have been provided for in the Constitution. So we've been able to explain them, and we've even mentioned that what we have in Chapter 5, they are not exhaustive because of the language of Article 33, Clause 5. So we shall now move on to the second part. Let's go back to our introduction. What did we say we discuss the second part? We said in the second part, we shall discuss Edusei number 2. So let's see whether that's what we have over there. Alright, so the second part. Now, second part. By the dictates of Article 33, Clause 1 of the 1992 Constitution, where a person alleges that a provision of the Constitution on the fundamental human rights and freedoms has been or is being or is likely to be contravened in relation to him, then that person may apply to the High Court for redress. It is important to take critical note of the expression, quote, in relation to him, as well as the expression, quote, that person, as used under Article 33, Clause 1 of the Constitution. These expressions connote that it is the very person whose fundamental human rights is being breached that can apply to the High Court for redress. The interpretation placed on Article 33, Clause 1 has been given judicial blessing in the case of Edusei number 2 versus the Attorney General, in which case it was held that since the crux of the plaintiff's case was anchored on the seizure of his passport, which prevented him from traveling into and out of Ghana, then the applicant rather had to institute the action in the High Court pursuant to Article 33, Clause 1 of the 1992 Constitution, which confers on the High Court exclusive original jurisdiction in all matters related to the enforcement of fundamental human rights, which directly affected the applicant. The brief facts of this case are that a Ghanaian citizen had his passport withdrawn following investigations into some activities by the security agencies. He was then sent off to the United States in exchange for another person who had been arrested in the United States on espionage charges for spying for the government of Ghana. After the applicant had stayed for some time in the United States and sought to return to Ghana, he requested from the Foreign Ministry and BNI the restoration of his old passport. And when he had not heard from them, after some time, he then instituted an action in the Supreme Court, arguing that since he was a citizen of Ghana, he had the constitutional right to, under Article 21, to enter and leave Ghana. Consequently, the continued seizure of his passport, which prevents him from entering and leaving Ghana, is a breach of his rights under Article 21 of the Constitution. The Supreme Court, in upholding the objection raised by the respondent, held that It was wrong for the applicant to institute the action in the Supreme Court because the substance of the action was that the applicant was seeking to enforce his fundamental human rights under the Constitution, and not that he was seeking an interpretation of the Constitution. The Supreme Court, therefore, in relying on the combined effects of Articles 2, Clause 1, 33, 130, Clause 1, as well as 140, Clause 2 of the Constitution, held that even though the Supreme Court was empowered by Article 130 of the Constitution to enforce the Constitution, such an enforcement jurisdiction did not include the enforcement of fundamental human rights in relation to the liberties of the individual as a court of first instance. It was therefore held that by the dictates of Article 33, Clause 1 of the Constitution, the High Court has exclusive original jurisdiction in all matters related to the enforcement of human rights provisions which directly affected an individual as an application before the courts. What have we said in this paragraph so far? In our introduction, we said that in the second part, we would rely on the case of Educe number 2 and Article 33 to demonstrate that the person that has capacity to file a fundamental human rights action pursuant to Article 33 must be the person that has a personal interest in the matter. In this Educe case, as we've seen, it is his passport that he was looking for. So if you want your passport, why do you go and bring the action in the Supreme Court as if you want an interpretation or enforcement? Since it directly affects you, the Supreme Court is saying that on the strength of Article 33 Clause 1 and Educe number 2 verse Attorney General, since it directly affects you, you must bring your action to the High Courts. Let's go to what did we say we'll do in the third part? What did we say? Let's go to the introduction to the third part. In the third part of this essay, I shall rely on Fediac. So now let's go to the third part and see what is about the Fediac. So, however, in the case of Fediac versus Public Universities of Ghana and others, the Supreme Court held that when the human rights provision that the applicant is seeking to enforce is not a breach of his personal human rights, but the applicant is rather seeking to enforce a provision contained in Chapter 5 in the public interest, then such a person can properly bring an action to the Supreme Court for a declaration to that effect. In this case, the applicant instituted the action in the Supreme Court, arguing that the full fee paying policy practiced by the universities was discriminatory and therefore in breach of Article 17 of the Constitution. In this case, even though the applicants were alleging a breach of Article 17 of the Constitution, they did not, and I repeat, they did not institute the action on behalf of any of the members of the plaintiff. Rather, the action was instituted in the public interest. The Supreme Court therefore held that to that extent, they had jurisdiction to entertain the action, to interpret and enforce the human rights provision, even though it fell within Chapter 5 of the Constitution. What is happening here? The Fediac plaintiffs, they didn't bring the action to enforce Article 17 in their personal interest. They brought it in the public interest. And the Supreme Court held that if it's in the public interest, then they can bring the action under Article 2 and Article 130. I proceed reading the answer. This decision of the Supreme Court is consistent with its previous decision in the case of Ejiampofo versus Accra Metropolitan Assembly and Attorney General, in which case the plaintiff instituted an action in the Supreme Court, arguing that the practice of the first defendant, AMA, in employing certain persons to carry on their heads human feces from various parts of Accra was in conflict with Article 15 of the 1992 Constitution, which guarantees the dignity of all persons. An objection was raised on the basis that insofar as the action was seeking to enforce Article 15 of the Constitution would fall within Chapter 5, then the action rather ought to have been commenced in the High Court. However, the Supreme Court held that to the extent that the action was not brought in the personal interest of the plaintiff, but rather in the public interest, then the action could be properly instituted, pursuant to Article 2, Clause 1 and Article 130 in the Supreme Court. So remember, I'm pausing here to now explain. You remember in Eduse, because Eduse himself passport has been seized, that's why the court held that since he has a personal interest, he rather had to bring the action in the High Court. But as you said in Fediak and Ajiampofu, even if you don't have a personal interest, but you can show they are bringing it in the public interest, the court may still entertain your action. So we are done with the third part. What did you say? We'll discuss the fourth part. Let's go back to the introduction. So fourth part. In the fourth part, I shall discuss the remedies that have been provided for under Article 33 of the Constitution to enable the High Court to give effect to its orders. So let's go to the fourth part. Right. Having spelled out the scope of the respective jurisdiction of the Supreme Court and the High Court in enforcing fundamental human rights, it is pertinent at this point to briefly discuss the remedies available to the High Court in enforcing the fundamental human rights of persons. Article 33 Clause 2 provides that the High Court, in enforcing the human rights provisions, may issue such orders or writs, including the orders in the nature of habeas corpus, certiorari, mandamus, prohibition, and prohibition. Habeas corpus has been defined as a writ directed to the person detaining another and commanding him to produce the body of the prisoner or the person detained with the day and cause of his caption and detention, to do whatever the judge or the court awarding the writ shall consider in that behalf. Quo warranto also refers to the prerogative writ issued when there has been a usurpation of an office of a public nature directed against the person who has so usurped the office to produce the warrant the person has to occupy that position. And then certiorari is also a prerogative writ issued by a court, which is to quash a decision taken by a lower court or administrative body, which is contrary to statutes, without jurisdiction, or in breach of the rules of natural justice. In the case of Awuni and Wayek, the court issued a writ of certiorari to quash the orders of Wayek to cancel the results of the students when Wayek had not given the students the right to be heard. The conduct of Wayek was in breach of the constitutional rights of the applicants to a fair hearing guaranteed under Article 23 of the Constitution, and therefore the decision was accordingly quashed by certiorari. What have we said over here so far? We have given some of the remedies or orders the courts can give if they are supposed to be enforcing fundamental human rights. And an example is certiorari that in Awuni and Wayek, when Wayek cancelled the students' results without giving them a right to be heard, the court took the view that it was an affront to Article 23, and therefore the decision was quashed. So we're done with our fourth part. Let's go back to our introduction. What did we see after the fourth part? So after the fourth part, we said the fifth part shall then conclude the discussion. So now we are going to conclusion. So conclusion. In conclusion, I have, in the following paragraphs, demonstrated the scope of human rights that are protected by the Constitution, the courts that have jurisdiction to enforce such fundamental human rights, the capacity of such persons to initiate actions to enforce human rights provisions, and the remedies the High Court can grant in enforcing such fundamental human rights. Remember the structure. You tell them what you are going to say, you say it, and you tell them what you have said. So in our introduction, you told them what you are going to say, you said it, In conclusion, you have summarized all that we have said. There are a few good points about this answer I want to draw to your attention. And it is the use of topic sentence. When you are beginning every paragraph, it is good that you give a topic sentence that will clearly show what the paragraph is already about. So if you look at the paragraphs, this one, for example, clearly tells you what we are going to discuss in this particular paragraph. That to start with, chapter 5 provides for the fundamental human rights and freedom of persons. So we know that's what we are going to discuss. Next paragraph, look at the statements. By the dictates of Article 33, Clause 1 of the Constitution, where a person alleges that the provision of the Constitution relating to fundamental human rights has been or is being likely to be breached, then that person applies to the High Court for redress. So whatever is going to happen in this paragraph is going to affirm this particular statement. Next paragraph, Fediac, look at the statements. That, however, in the case of Fediac versus public universities, the Supreme Court held that when the human rights provision that the applicant is seeking to enforce is not a breach of his personal human rights, but the applicant is rather seeking to enforce a provision contained in Chapter 5 in the public interest, then that person can properly bring an action to the Supreme Court for a declaration to that effect. The opening statement tells you what you are going to discuss. Some people would want to mention the case, go and bring facts and holding, and they'll be wasting time. Meanwhile, the most important part of the case is the holding, and make sure you have captured it in your opening statement. Now, if you look at this one as well, for this paragraph, it tells you what we are going to discuss in this paragraph. That it is pertinent at this point to briefly discuss the remedies available to the High Court in enforcing the fundamental human rights. So take note of this structure. It helps you to be on track, have a good introduction, make use of topic sentences, be always limiting yourself to the law, and do not deal with any extraneous matters. And your essays will be quite comprehensive, and then we can all understand it. So this way, I shall draw the curtains on the question that reads, assess the strategies and instruments provided in the 1992 Constitution in respect of how a person or citizen might protect his or her fundamental human rights and freedoms guaranteed under the Constitution. Your answer must reflect specific provisions of the Constitution and decided cases. This is where we shall draw the curtains. Thank you.